Today we had a session on excessive pricing in pharmaceuticals, and I have the pleasure of having with me John Davies, currently at Compass Lexecon, former head of the competition division. John, as former head of the competition division, you were here in 2011 when the last roundtable on excessive pricing took place. What do you think changed in the meantime?
Well, I think what's changed has really been some of the case practice, that we have seen competition authorities taking more cases on excessive pricing, including some competition authorities that had perhaps not had any experience of doing that before. I'm thinking especially about the United Kingdom, my home territory, where at the time of the 2011 roundtable, I think the UK's only excessive pricing case had been in pharmaceuticals, but it was a very unusual excessive pricing case in that it involved both exclusionary abuse and excessive pricing. It was a kind of predatory pricing case with the excessive price providing the recoupment. So I think what we're seeing is a lot more pure excessive pricing cases, if I can use that phrase, and particularly focused on the pharmaceutical sector. So it's obviously a very topical roundtable.
And what do you think about the suitability of the pharmaceutical sector as a target for excessive pricing enforcement?
Well, I need to take a bit of a step back there because my own view is that excessive pricing within the EU context under Article 102, I'm a bit of a sceptic about that. Obviously, competition authorities do have to enforce the law, but equally I observe that in this particular area of the law, excessive pricing under Article 102, many countries and the European Commission itself seem to manage for many years at a time without ever enforcing this particular bit of the law. So I think that you've got to look at the facts of the case, you've got to look at the individual circumstances of the case. But I think particularly with pharmaceuticals, the question's got to be, if there is a problem in this sector, is the way to deal with it to find a company guilty of breaching competition law in the past? Or is there actually something we can do with regulation to solve some more systemic problem which is perhaps giving rise to this? And I think that's almost always going to be something that should be a very live concern for competition authorities in this sector in particular.
Okay. Thank you very much, John.
Thank you.
Thank you.